Yes, good morning to those of you who were here yesterday, and good morning to those of you who are new. I should say that we set a very efficient standard yesterday in that we dealt with the appeal, all of the issues in the day. That's your task, to emulate that if you can.
We'll do our best, Margaret. May it please, my lords, I appear for EasyGroup along with Mr Fancourt today, and Ms Himsworth appears for EasyFundraising parties along with Mr Akins, who you'll recall from yesterday. This is, there are 8 grounds of appeal, and with your lordship's permission I propose to take them in order of our skeleton and the order in which they appear. Just to briefly survey the field in terms of what those grounds raise. The first ground is a direct overlap with the matter you heard yesterday. We had permission from the trial judge on that, and that involves variant use of EasyLife 1, the first EasyLife trademark, where the deputy judge in yesterday's case went the other way from our judge. That was a total knockout in our case. It wasn't about partial revocation, it was about the mark goes because the use was not sufficient.
Yeah.
The second ground, assuming EasyLife survives, that mark survives, is a ground on partial revocation on grounds of non-use, insufficient use across a range of the specified services. Then the third ground is partial revocation of the first EasyJet mark, and that's partial revocation to contain a rider that it be limited to airline passengers, retail services for airline passengers, or as my learned friend would have it today in the respondent's notice, in-flight services, in-flight retail connected with the various things that they sell. The fourth ground is we say incorrect revocation of the easy.com mark. That was revoked in its entirety for email services because it was said not to have been used as a trademark for those services, but as a kind of giveaway. And then grounds 5, 6, 7 and 8 are infringement grounds.
Yeah.
And when we get to them, I'll address you on the impact of earlier findings, which you will not have made, I hope, by that point. And you will, as it's in my favour, and then whether that has an impact on the overall likelihood of confusion analysis. Because of course, when it comes to infringement, there are 2 basic factors you need to consider: similarity of marks, similarity of goods or services. And so obviously, if there's a major shift in the second of those, then that does require the analysis to be retaken. We say to a different result, my learned friends say to the same result. And it may be that the Lords have certain questions for me on how that exercise can be carried out, because there are rather a lot of potential infringement findings that the court will be required to look at one way or another if it is of the view that any of the revocation grounds 1 to 4, get anywhere. So just to preface this section of my submissions, trademarks are potentially perpetual monopolies, subject only to renewal, but they operate on a so-called use it or lose it system, which is that applying for a trademark gives the proprietor a 5-year period from registration where it can sue on the mark without any concerns about whether it's used. But after 5 years, to maintain the mark or to sue on it, as you will have seen, the proprietor could be required to show use, and if it hasn't been used, it's revoked in part or in full. Now, it's common ground, and the statute says so in section 100, that the burden is on the proprietor to show what use is made. And we embrace that. We don't have any difficulty with that. The case actually is much less about that, one of the grounds does to concern how much evidence was adduced, than it is about characterization of that use. And at that level of the analysis, that stage of the analysis, there isn't any burden one way or another. It's a question of the court looking at it, characterizing it, whether it's appropriate to introduce subcategories and whether it's use of the of the same mark and so on, or a permissible variant. There aren't any burdens at that stage. So it's just important that the court has in mind that we embrace the burden on use, but not anything more than that, because that's just about legal characterisation of the use. Now, there's plenty of case law that is in the bundles on permissible variants and subcategories, etc., and none of those suggest that there's any particular allocation of burden or threshold or anything at that stage. It's the test. The test is what it is. Now, the issue arises here because two of the marks, the judge held there was no valid use at all. There was simply that they had to go. Now, there had been use, but it wasn't valid use, it wasn't legitimate use. And so the first of those is ground one, the revocation of EasyLife 1, as I call it, or the first EasyLife mark, in its entirety due to the use of an impermissible variant. Now, I propose this is one area where I propose to maybe save a bit of time and stick to your mandate, because I hope I don't need to address you too much on the law of this, because I understand you looked at it to some extent. But we say that the basic proposition here is that the proprietor is regarded as having used a registered trademark if the use that is made doesn't alter the distinctive character of the mark in the form on the register. Now, we know from the case law that you look at the distinctive character of the mark as registered, you look at the distinctive character of the mark as used, and you ask yourself if the registered mark's distinctive character has altered. Now, the law was correctly stated by the judge, we say, it's common ground, but his application of the law was in error, we say. And that's partly because he did not specifically address the meaning and contours of the concept of distinctiveness.
Concept of?
Distinctiveness, what distinctiveness is. And in the judgment, there was quite a lot of focus on the design of the mark, on whether something was decorative, whether it had visual significance, and all of that is by the by if it doesn't affect the distinctiveness, because it's the distinctiveness that makes a mark a legitimate variant. If that hasn't changed, then it hasn't gone up significantly or gone down significantly, then it's a permissible variant. It isn't just about visual difference. That's very important, because two marks could actually look quite different, and you've seen those in examples, the cases. I don't want to just refer to the ones that helped me. Each side put in examples that they say support their case. But by and large, what you have is a number of cases where the use looked different as a picture from the registered form, nonetheless held sufficient. And the reason for that was because in each case, the court asked itself, is that any more or less distinctive than the original version? And in each case, it held no. I mean, I don't want to turn to the case if I can avoid it, but cases like the Budweiser case, which I know you looked at, they look vastly different. The shape of the letters, everything. But the reason why that was permissible was because so far as the registered mark was concerned, its distinctive character didn't alter according to whether it was presented in a Gothic 14 script or had a bit of decoration next to it. And the reason for that requires the court to consider how distinctiveness works in the context of registration of trademarks. And when it comes to registration of trademarks in section 3, and I don't believe you addressed on this yesterday, section 3 requires marks to be distinctive to get on the register. And the principal provision that has relevance to our proceedings is probably section 3.1b that says a mark should not be devoid of distinctive character. But if it has some distinctive character, it can be registered, a minimum degree of distinctive character. But what's important is when you look at how that exercise is carried out. So a descriptive word cannot be registered. It would fall foul of either 3.1b or 3.1c. A word that is simply generic might just be a 3.1b case. A very simple design, 3.1b case. But what's clear from all of those cases, and I'm taking in years and years of jurisprudence as I say this, but I'm summarising it, is really that in general, if you've got a descriptive word to start with, or a word of very modest degree of distinctive character, getting it up in a bit of fancy stylisation doesn't make a blind bit of difference. It will not get that mark on the register. So we've given an example of it in our submissions of the word shopping. If you had the word shopping, you tried to register it for retail services, and instead of the tittle, you know that that's a term of art for the, that's a technical term for the dot above the I. If you replace that with a little cube or a little triangle or a little star, it's not going to make any difference. The mark will be refused. So it's with that in mind, you get an idea of the significance of stylisation such as that was applied to the words easy life in this case. There's a secondary reason for this, which is that in general, trademarks law favours and privileges words above non-verbal aspects. So in other words, that's a general rule. It's actually referred to in the Sony case, which is in our authorities, but it's a sort of general point that that words speak louder than other aspects, and they really do the distinctiveness work, the distinctiveness lifting. Now in this case, the judge held that the trademark was of modest distinctive character. Sorry, the word aspect was of modest distinctive character. Be that as it may, it's a registered trademark. In my submission, it had amply satisfied the requirements of being so, and would have done so even as a plain word, because it is a neologism. It's a combination of two words to form a new word. Easy life is not descriptive of the particular services in question. Might be said to be vaguely laudatory, but not sufficiently. It's what trademark lawyers sometimes refer to as an allusive mark rather than a descriptive mark. So something that gives you an indication or a suggestion as to its qualities, but doesn't directly describe anything. So we say that fundamentally, looking at the registered trademark, there had to be an assessment of its distinctiveness in the form as registered. And in the form as registered, it was essentially the word easy life, combination lowercase e, for these services, and it was a bit stylized. Now, when I say that, I don't mean to say that the visual aspects of stylization can simply be airbrushed out, but they have to be assessed for their value as distinctive signifiers. And something like a triangle of indeterminate semantic meaning is not going to mean a great deal in terms of the distinctiveness equation, because it doesn't tell you anything about the services, that it's got a triangle above where the dot should be. And the other point is it's exactly where the dot should be. So it looks like someone's come up with a fancy dot on the word easy life. The only other aspect of potentially of difficulty is what about the strap line underneath, words underneath? Well, first of all, they're barely perceptible mark in ordinary use, but they're there, so we've got to give them some significance. We say those perform a different function from the mark, the essentially distinctive nature of the mark. A strapline, and that particular strapline is a good example, generally is a sort of chatty or exhortational or laudatory phrase that accompanies the distinctive mark. Every little helps, or whatever it is, to the Tesco. These are notoriously difficult to register on their own, with slogans of that sort. And the reason for that is they're generally not distinctive. They are sort of advertising language or marketing speak. So those are the two aspects of this mark in the form as registered that the judge held would contribute to distinctiveness. And we say the reason for that error was that the judge did not appreciate that the exercise was one of assessing distinctiveness in terms of the capacity of those elements to contribute to the mark's ability to indicate origin. Now, when it came to, again, I don't mean to suggest that those had no role. I don't say that they're being airbrushed out, but it's a question of assessing whether they had a trivial role or a meaningful role. And we say, at best, they had a trivial role such that their omission in use would not affect the distinctive character of the mark in the form as registered. Now, when you look at the examples of the variant use, I should probably turn it up. I think the judgement's probably the best place to. Yes.
It says tab 10.
Tab 10 of this page of judgment. Sorry, papers are a bit. There we are, 140 of the judgment, page 140. So you've got a number of marks which are called sort of tick ball variants for obvious reasons. They've got different, either an absence of a slogan underneath or a different slogan. Yeah. And then you've got text variants. I understand that the last of those was dropped as a manner of use. Now, so there's a text variant. We'll just say right off the bat, Easy Life text variant, we say that's permissible variant of the mark because it contains all of the meaningful distinctiveness of the mark in the form as registered. It may as well be a text-only mark. And by the way, don't be distracted by the capitalization because all that is conventional form for communicating that it is the word alone that's being claimed. So it's not the fact that it's Times New Roman font, all caps. That's not what's claimed. It's a word solus, as it's called, protection. So we say that is really the end of it. But to the extent one looks at tick balls, first of all, they contain the word fundamentally in lowercase. What's more, the judge seemed to be taken by the fact that there's a different font. Which it may be, it's another sans serif font, it is a bit different. It has a sort of, if you look closely, it's got a kind of incline halfway through, or sort of, and then a decline. But really, we say there's very little difference there. Already addressed you on the separate slogan, which we say is really not part of the distinctiveness either of the mark in the form as registered or this use. And then the tick ball. Well, the tick ball brings into play another issue, which is that these uses, as they're put there, are in a sense artificial because they show use of a logo and a word. Now, they're not integrated into a single mark, and in the consumer's perspective, a logo form, which can't be pronounced, which doesn't necessarily have a clear meaning, vaguely laudatory, A approved with a tick, Easy Life maybe, but actually it's more fundamental than that. It doesn't affect the distinctiveness of the mark in the form as registered. Because the mark in the form as registered is there next to the tick ball in virtually unchanged form, or distinctively unchanged form, and the separate logo has a different role in consumer perception. So
do you say the tick ball's irrelevant?
essentially, yes, we say it is irrelevant in the sense that it doesn't alter the distinctiveness of the word in the form as registered. It's relevant in the sense that we've got to establish the parameters of where we say the use begins and ends, and it's in our list of potential uses, so we don't completely ignore it. But it has a different function. It's always been the law of trademarks, variant use, that there's no requirement to use a mark on its own. So you have, for example, let's say you have a wine label where you've got the name of a wine, and then you've got other language underneath it, you've got the brand, and then you've got other language underneath it. That doesn't change the use of the mark in the form as registered. That's simply additional matter. It's added to it. And of course, a word versus a logo, they perform different functions. One is primarily visual and operates on a sort of symbolic level to indicate approval or something is good. And then the other is the actual trademark, which is the easy life aspect. So on this, these are points that the judge didn't really consider. We say the judge focused on the decorative aspects to the detriment of actually analysing distinctiveness as carefully as it needed to be done. If you look, a passage from the judge's judgment in our skeleton. Convenience. The judge made several errors in addition to this point about not assessing distinctiveness. And
Which paragraph?
I'm just going to find that for you. Sorry, yes. It's the passage below the easy life mark on paragraph 34 of our skeleton, page 44 of the bundle, tab 6.
But in the judgment at...
The judgment's at 155.
155, thank you.
Paragraph 155.
Paragraph 155.
Page 140.
That's at C10, 140. Yes. So, and there the judge is describing the mark in the form as registered. The mark comprises the text written in black type as a single word, all in lowercase, with a strap line beneath that. So he does understand that it has a strap line, it's sort of separate to the text, which is reference to the word easy life, and a decorative element that can be seen either as a triangle, part of which is shaded to create a tick shape, or as a pyramid, two faces of which are darkly shaded. We agree with that, essentially. That is true as an analysis of the picture that we are looking at, but also the significance. The triangle doesn't clearly connote anything that people would understand. I know that hasn't always been the argument on behalf of EasyGroup, but that is the position we would say here on appeal. And we say that the strapline is just that, as I've submitted, and that the font is unremarkable. So you are left with something that we say has its distinctiveness, wholly or almost wholly, I can live with as well, in relation to it arising as a result of the word, because the law should not be concerned with any trivial levels of distinctiveness that might be supplied by other aspects.
Can I just understand what we're doing here? Because the submissions you're making, if we were the tribunal reaching a evaluative decision, are all very powerful.
Yes.
But we have here an evaluative judgment by the judge. Essentially in 156, the distinctive character lies in two parts, the conjoined words and the design. So is your submission, I think your submission is that as a matter of law, the distinctive character must lie in the words alone.
No, that's a factual evaluation.
Yeah. So presumably your submission is that no reasonable judge could have concluded that the distinctive character lay in both parts.
We say that, but also we say the judge did not really ask himself the question of how the distinctiveness is altered. I mean, I understand what my lord is putting to me, which is that he does reach findings on distinctiveness, but he had not considered what distinctiveness means from the perspective of registration of trademarks. So that's really the only bit that's missing there. But of course, he then goes on to commit clear errors in other respects, which I was about to take you to. So he, for example, relies upon evidence of a former employee of EasyLife as to how to assess the mark. And that we say is illegitimate. I mean, you can call evidence on distinctiveness in rare cases, but it should be quantitative survey type evidence. So you could have members of the public and you can hold it up and ask them questions, non-leading, and hope that your survey passes muster. It's possible then, but the judge here relied upon the evidence of the employee, but also there was another...
Mr. Wise.
Yes, Mr. Wise. And that was part of the judge's analysis. No doubt that that was part of it. And then, secondly, the judge made a very strange finding, we say, of, this is at 48, 49 of our skeleton when he's interpreting Watson, that somehow the reasons for using the variant are relevant. Now, I can see, to be fair to the judge, how the judge got there, because...
Sorry, again, if
Sorry,
I could
take
just have the paragraph of the judgment.
so the paragraph of the judgment is 169, C10,
169.
169, and then C10, 143. Now, we think what happened here was somewhat understandable but still wrong. So the decisions on this area of law, Specsavers is the most significant one. They say that the reason for section 46, for the doctrine of variant use, is that you've got to have some tolerance in the system so that traders can evolve their marks to suit marketing conditions. And that's stated as being the policy behind the provision. And that is the case, so far as the legislators are concerned. But it does not mean that that's the test. The test is the statutory test, which is simply a comparison exercise of the distinctive character in the form registered and whether that's altered. There's no requirement to somehow justify your departure from the registered form, and yet that is what the judge is doing here. As we've said in the skeleton there, the judge imposed a requirement of evidence justifying the use of the variant form and or for evidence that it was impossible to use the mark in exactly the form as registered. Special reasons for non-use by another route. And whilst there may often be such reasons, they're not required. So,
I'll just take you back to my earlier question.
Yes, of
just
course.
so I actually got your answer clearly. You're leaving aside these other errors. The key error is the judge didn't take into account distinctiveness in the context of registration.
And that is what distinctiveness is. So if you look at the Giordano judgment, the Walton judgment by Mr Justice Arnold, sitting as a High Court judge, he said that the approach to assessing distinctiveness is the usual one. And what he meant by that was, this is the exercise that we carry out when we're deciding registration of trademarks, how to look at a trademark, the important bits, the distinctive bits, and so on. There's no sui generis approach when it comes to variance. And so we say that although the judge certainly cited that judgment, that authority, That's the point that he didn't really, we say, understand, because his whole, including the findings that he reached on distinctiveness, because he had not properly registered the import of what distinctiveness is and what's supplied by what elements, typically, and in this case, he didn't ask himself the right questions that he answered in the paragraph that you put to me. So he might have reached on its face findings on distinctiveness that I have to overturn, but it's because his approach to that question was flawed that we have no confidence that he was asking himself that question, because otherwise, and it might stray into the irrationality, otherwise you could not say that some unspecified little object above the eye would be distinctive. I mean, it could have some kind of trivial level of distinctiveness only on the visual, not on the conceptual or on the oral, but it could not be this great determinant of the distinctive character of the mark. It just simply could not be. And likewise, the strap line, well, he himself held the strap line is a strap line, and that's our submission in relation to that. It's not part of the mark. It's a sort of separate aspect of it.
So just what is the question he should have asked himself? Yeah, I think you where you opened it was he didn't address the meaning and contours of distinctiveness.
Yeah. He should have asked himself he should have defined distinctiveness, which is the ability of a mark to indicate origin. And then he should have asked himself, in a case, looking at the Easy Life mark, do these elements, are they capable of meaningfully or significantly, more than trivially, affecting the issue of that mark's ability to indicate origin? This is where our shopping example comes in, because the good thing about that example is it isolates the role of the elements. Obviously it's artificial, it's not this case, our mark is not as descriptive as shopping, but it isolates those elements because it says, would you get that mark onto the register just with those elements? Because if the answer is no, it's very difficult for you to say that they're contributing to the mark meaningfully. Take, for example, if it had, instead of a dot or a triangle above the eye, it had a picture of a puma playing a violin. Take an example from the actual case law. That could well be distinctive visually. Unusual, fanciful, it's a device. You can put that on clothing or something, or on your retail merch or whatever, and that would be different. But this is just a sort of slightly triangular device that isn't capable of being well understood and is in the usual place. Its absence will not be missed. It will not affect the distinctiveness of the mark as registered if it is not there. These are questions that we say he did not ask, and that's the essential problem. But of course, these other errors that he made about evidence are also important. They are part of his reasons, and they alone warrant vitiating the decision on being erroneous and for the court taking a fresh decision.
So I think your submission is to identify the distinctive character. You have to look at the other bits and ask whether in relation to those, they in themselves would justify registration. If they would not in themselves justify registration, their use in a variant cannot, or absence in a variant, can't alter the distinctive character.
That is one way of deciding the question. I wouldn't want to replace the test with that, because that's, that may not be appropriate for all cases. But what that exercise does do is give you some idea of the tolerance in the system for immaterial variance. So, material variance, permissible variance. That gives you an idea that if you consider those aspects and elements on their own, and you think they wouldn't be enough in those circumstances to do the work, then they obviously are not performing such a great function in this mark either. And they wouldn't even on a highly distinctive word, because they're just aspects of stylization and so on. I mean, another way of thinking about it is this. If Easy Life, instead of the triangle on the top, it had a little cube, it would be clearly decoratively different, and the judge refers to the decoration It's decoratively different, but not distinctively. It's just a little cube instead of a triangle, instead of a pyramid or whatever. It's just a little bit of incidental stylization in the place where you might expect a dot to be. And slightly eye-catching, maybe. The test is not one of visual significance. The just check my notes. The other covered. Oh yes, there's a point on there. Which one is an issue? Which I'll come to. So these, some of the case law on this is worth looking at. I know that you didn't. Oh, I don't think you were showing the Sony case. In your,
We were.
Oh, you were. I'm grateful. So the Sony case, which you'll see in our skeleton, is just. I just wanted to make one point on that, which is that they're clearly visually different. Actually, we don't need to turn it up. They're clearly visually different. It's a different robotic, futuristic writing or lettering. And Budweiser the same. It's clearly different lettering. It's decoratively different, but decoration is not really part of the concept of distinctiveness. Decoration is eye appeal or attractiveness or artistic choice. It's not about whether people can latch on to that mark and know that it comes from a single undertaking. And they get that to the same degree in the uses and in the registered. Yes, I think probably now's a point to mention a point raised in paragraph 59 of my learned friend's skeleton I need to address you on before I come to the second round. Read this with a little bit of surprise because it seemed to be a sort of TKO that she's running. If you just remind yourselves of what it said in paragraph 59. So the position is that we have overlooked to specifically put in play tickball lifestyle variant, which was the one that the judge held was used for advertising services, and others were not. And because we didn't challenge the factual finding on whether that was the only one using advertising services, says the respondent, gotcha. There's no point considering the second ground. Now, on this, we say, well, first of all, I've already submitted to you that the use of the word alone, the text variant, is sufficient, and that is use of the mark. So to the extent that that was contained in the documents, that's enough for me, and that's already in play. That's part of the text ball variant as well, because it's the mark, it's the word. But if it, to the extent we do need to formally put in play, I would seek to invite your lordships to grant me permission to argue that on the basis that this was nothing more than an obvious oversight, in the sense that we would not have been, if my friend was right, and it was sort of a deliberate choice by us, then we would be a bit silly seeking to argue that it had an effect on the advertising services and that we were in a better position on infringement. Secondly, of course, we would be arguing that uses that were further away from our registered use, in the sense of the wording of the strapline, you'll see that the strapline is lifestyle solutions. Is that the one? Lifestyle solutions, and that's the strapline that's actually on our registered mark. So it was an oversight not to have mentioned that, but and not to have mentioned that, and not to have challenged the judge's finding that that was the only one used for advertising services. But we would respectfully request the court grant us permission to run that to the extent we need to, if you're not with me, on textual use, being use of the mark. What's that? Yes, of course. My June points out that, of course, the tick ball. So if you look, what are we? That's paragraph 158 of the judge, but you can see them set out at page 140. Just so you know what I'm talking about. I probably should have shown you this immediately. In the paper version, it's spread over 2 pages, but you've got 33 and 34. So the one that we haven't, by omission, put in play is the tick ball lifestyle variant, black 1/3 from the bottom. And we say...
And you say that makes no sense at all in circumstances where you are relying on the everyday variant,
Exactly.
which is further away.
Yeah. And we also say, for what it's worth, the tick ball variant, the blue one in A, is also used in the tick ball lifestyle variant, but with the addition of the strapline. So, I mean, I mean, it's a bit embarrassing. We wanted to, we meant to put that in play, and I'm sure my learned friend didn't mean anything by it, teasing us about it, but we intended to put that in play, and we would respectfully request that it be in play so that I can turn to ground 2. But perhaps I'll just turn to ground 2 in any event on the assumption that my lords need to think about that. The ground 2 is partial revocation of this same mark, but now we're going to look at the services. Now, problem here for us is that we had a registration for advertising and promotional services, and the judge imposed a sort of limitation on that, or rewrote that as providing advertising and promotional space in printed publications. And let me just say right away that the evidence in the case was that we had only worked with printed publications and provided inserts and the like to make promotional space in those printed publications. So the question here is not whether we were at odds with the refined specification, it's whether the judge was right to even go down the route of refining our specification. Because what I'm going to submit is, in fact, it's relatively rare for the tribunal or the registry to take the view that after 5 years you're going to be refined down to the actual use made. I mean, it's not automatic. It's frequently the case that you have used, you've never used all the possible commercial variations, but it's frequently the case that you keep your mark in the form as registered. We say that the message from the case law is that you proceed with caution in adopting the subcategory approach, and only where the use is somehow clearly a subcategory or a subset of the greater whole, which we say this was not. Let me just explain how the judge got to his decision. If you pick it up at 131 of the judgment, you can see he sets out 131 paragraph on the page. This is the section where the judge sets out the standard case law. 130, sorry, the page before that, there's the standard cases on revocation on grounds of non-use, summarised by Arnold or Justice Arnold in EasyGroup and Nuclear. Then over the page 131 is the specific case law insofar as it applies to the subcategory approach. Now, this is what Lord Justice Kitchen is doing there, and that as it then was, what he's doing in Merck is explaining how the process gets carried out once you've decided to carry it out. He doesn't actually in Merck say, you do this in every case. What you do is you have a look at the use made and you have a look about whether you're going to come up with a subcategory, because that is simply just not done. It's done in a case that's appropriate for it. But when you do it, this is what you do. You identify the goods or services where the mark has been used, and then you consider the registered services, And if the registered services are sufficiently broad that it's possible to identify a number of subcategories capable of being viewed independently, then use of the mark will not constitute use of the mark of the specified services. So, but equally, in 247, it's not possible for a proprietor to use the mark in relation to all possible variations, so care must be taken that it doesn't result in the proprietor being stripped of protection for goods and services, though which are not the same as those for which use has been proved, are not in essence different. And that's important because the otherwise, in every case, you would simply rewrite the specification to define what's been sold and what's been traded, and that would be done. And that would be essentially taking away the whole benefit of having a registered trademark over a passing off action, which is a passing off action protects the actual trade and goodwill. It doesn't protect anything more than that. And whereas a trademark is intended to give you a number of protection around your goods and services. So, and finally, it says, the Lord Justification says, these issues are to be considered from the viewpoint of the average consumer, taking account of the purpose and intended use, and ultimately it's the task of the tribunal to arrive at a fair specification. We say the word fairness is quite an important point in this case, because, and you'll see in later grounds, that the particular formulations arrived at by the judge, in this case, even in a related case, but even in the beauty perfectionist case, was simply not fair. It's a matter of trading competition. It wasn't fair. It was unfairly restricting EasyGroup's trademarks away from their true competitor markets. And this was something that should have been done with greater hesitation, I'm saying. But the only other case I wanted to look at, because I know that there's been a bit of a debate in the skeletons about whether Skykick from the Supreme Court makes any difference to the question. The significance of Skykick, of course, is that Lord Kitchen now said you've got to look at some of the more recent case law, ACTC and Ferrari. And I wanted to show you the Ferrari case, because in my submission, that is bang up to date. That is the test that you need to be applying in the light of Skykick and also in the light of the state of the European law as was. Bundle 3, tab 22, and I wanted to go straight to paragraph 37. It's the sideline section on page 737. Over the page, if I could ask perhaps the Lords to just read. It's about page and a half.
First. Tab 3, tab 22, paragraph
37 on page 737. It should be sidelined, this section.
Yep.
And if I could just ask my Lords to read to the end of the page 739. This is some fairly opaque, it might be said, guidance from the Court of Justice in a reference on Ferrari spare parts, Testarossa branded parts and vehicles. So if my Lords
Where did you want us to read down to?
I think probably the end of 53. It just goes over the page. Just to the side, the end of the sideline section. So what is going on there is a process of identifying when it is appropriate to adopt a subcategory and when it is not, without necessarily repeating intended purpose or use of the goods, because that formulation leads to the sorts of debates we have in this case, which is different arguments about what level of generality you adopt when it comes to the purpose. So the purpose of a retail shop at the airport or on a plane or duty free is different from the purpose of a high street shop, it can be said, depending on what you mean by purpose or nature, use. So what is coming through in this judgment is a slightly different point, which is that you look at the use made and you compare that to the specification and you ask yourself, to what extent is that typical of a general homogeneous class, broadly homogeneous class of goods or services? And with that in mind, you get cases such as this case and also the ACTC case, I call it the ACDC case on our side, and you get cases like that where the only use shown for a clothing specification was outdoor clothing, and that saves a mark for clothing. Now, of course, it is possible to have many different kinds of clothing that aren't outdoor clothing, that don't protect you in any way. But it's more a question of what does the consumer, when they think of the use that's been shown, and they compare that to the specification, is that broadly coterminous? Is it a part of a typical group of goods that would be considered to be the same? Are they all associated with the same sort of goods? Because in fact, when it comes to the specification of goods and services, in general, they're pretty precise. Most of them are taken from what's called the alphabetical list of terms, which are then organized into classification classes on the NICE classification. So then you're not starting with something that is necessarily broad. Judges always comment on trademark specifications being broad, but these are already picked usually from a list of many, many thousands of terms, and they already adopt something which is more or less usable and understandable. So something like advertising services, we say, in fact, the debates between my learned friend and the judge on this, Ms. Akins, I think it was, giving these various examples about Google AdWords, that being a different kind of advertising from banner advertising, we disagree. That's just the same kind of advertising as our advertising. The fundamental purpose of advertising is that you're getting that message in front of eyeballs, consumers, by some form of medium. That's what advertising services are, and anything that falls within that description is most likely to just be seen as paradigmatic of advertising services and to justify the specified services at that level of generality. Now, it's possible to think of things that could be subcategory type uses, and I think another examples of Mr. Akins was the creative ad agency or the copywriter, if my memory serves. And one could well see that someone who's involved in some niche activity within advertising that isn't just delivering the message to the masses in some form, that might be appropriate to be carved down. So we don't say that advertising services can never be partially revoked, but not a case where the activity is printed publications, so you're already dealing with a medium rather than the message, and arranging for space. But that's fundamentally what advertising is. It's space in media for a commercial message to be brought. apt to be diffused, and that's, we say, absolutely typical. And the consumer, to the extent it's a sort of a consumer articulation or conception approach, that's an advertising. You're in the advertising business. Insert advertising, whatever, but it's the advertising business, and it's perfectly appropriate to retain the full specification. Now, if I could just I think that is all the points on the advertising one, and I was going to then turn to the round 3, which is the EasyJet second mark. Now, the EasyJet second mark is again part of a partial revocation for a subcategory, so it's convenient to deal with it now. The definition or the restriction was, sorry, the starting registration was retail services connected with, let me just cite it exactly. That's theirs. Yeah. So if you take tab, it's this one. Sorry, the specification in the original form before prior to revocation.
So that is
Thank you. Right. Okay. This one here. Yeah. Right, it is there buried. I've been looking at it at the table. Okay, so it's paragraph 20 of the judgment, page 111. And you can see that it was originally the EasyJet word mark registered for class 35 retail services specified as, and then the words that come after that, retail services connected with the sale of food and drink, preparation, substance of the use in the care and appearance.
Sorry, where are you reading from?
Paragraph 20 of the judgment, where there's where they recite the judge recites the specification rather than read it out. I'll just let you. I should say this is a pretty typical retail services mark. So retail services mark just generally it says either retail services and then connected with the sale of, and then it mentions things, various could be goods or services. Another way it's sometimes put is the bringing together for the benefit of others. Various horsewhips, saddlery, stirrups, whatever it might be. And often the certainty or the narrowing in a retail services mark is provided by the things to be retailed rather than the manner of retailing. And the reason for that is quite a good one, which is that retail is retail. And that's why, as a starting point, we say one has to approach partial revocation of retail services marks with a degree of care, because they are more than anything defined by what you are retailing rather than the actual manner of retail. Now, what the judge did here was add to that, provided to airline passengers. And that brings into play the question, a number of, we say, legal errors, but also quite significant points on where you draw the line when it comes to partially revoking marks as a matter of policy, because what the judge did, we say, by partially revoking, partially revoking our mark to airline passengers. If you think about it, what the judge was doing was saying you can have a mark for your own customers. That's it. And that had to be the case because we're not selling to BA airline passengers. Can't sell to BA ones or Ryanair, Wizz Air. Selling to our own ones. So it's basically saying the defendant has the mark for sales to its actual customers. And that's just wrong as a matter of principle, as well as being not fair as a matter of principle. Let me start with the basic problems with it. By focusing on the airline passengers, the judge focused on the consumer rather than the market. Those consumers and those airline passengers want to buy a bottle of perfume at some point to take on their trip to Spain. There are a number of places they could get that bottle of perfume. They could buy it from EasyJet by pre-ordering, or they could pick it up in duty-free, or they could buy it from the local Boots next to their flat before they go to the airport. Take it in their luggage or hand luggage. The point here is that EasyJet is competing against those other retailers. It can't be right that it should be shackled in its trademark, which gives it a right, effectively an exclusive right over the word EasyJet for retail, that it can't stop a competitor using something like EasyJet in retail because it's been shackled in the field of only airline passengers, when economically and competitively it has to compete with these other businesses, and they don't get exclusions from airline passengers. Another way of thinking about this is the inherent ambiguity in the term airline passengers. This is one of the main problems, or one of the sort of more general problems of trying to define trademarks by reference to the public. Because who is the EasyJet passenger? Or sorry, the
Well, it
airline
doesn't say
passenger.
EasyJet, it says airline passengers.
Airline
So it could be a different airline.
Could be a different airline, but the question is, am I an airline passenger because I'm now holding a BA ticket to Spain in 6 weeks' time? If so, then you're saying EasyJet is put at a disadvantage against Boots. Or does it mean I went on an EasyJet or a BA flight last year, so therefore I am part of the public known as airline passengers? It's just not a principled way to look at the trade that's been carried out. And that's a fortiori in relation to in-flight, which is, of course, the respondent's notice on this. The respondent's notice is, well, we'll take your airline passengers and we'll raise you in-flight. It's really difficult to see how in-flight could be appropriate when that's the one place where there's no transaction being carried out, no goods being delivered, and no selection between different undertakings to purchase those goods.
Is that right?
I don't understand that. What do you mean?
So this all comes from the beauty perfectionist case, which is where Mr Justice Bacon held that the appropriate rider for this specification was that it be confined to in-flight retail connected with everything that comes after that. And bear in mind that in that case, the judge did not have any evidence of pre-ordering. So I think she was not prepared to assume that there was pre-ordering, and may have, I don't know, assumed that the purchases were taking place on board in flight, because that's, you don't normally, I don't think you can buy duty-free on board planes until it's in the air. So maybe
They
that's
spend all their time trying to sell you stuff
Yeah.
on a flight.
on the flight. So you can imagine that sort of situation.
On board.
Yeah, but in this case,
You don't get food, you don't get drink, but you get endless trolleys of overpriced perfume.
as opposed to the very cheap fare that you got to travel. The point is that there's no doubt that there is an in-flight retail trade, but this case was broader than that, even on its on the common ground facts, which is that there was pre-ordering, which could take place well before you even went to the airport, and that resulted in the goods being delivered on the plane. But so you'd already transacted before then. There were also purchases on the plane, but there were also purchases before that. Yeah. So the reason we say that in-flight is wrong.
And also, is this in-flight in UK airspace? Because if it's outside UK airspace, it's not territorial.
It's not a territorial sale. Yeah, that's exactly right. We say that there was pre-ordering here, which brought it within the territory and also brought it within. It had to compete with the duty-free shops that you have to battle around to get to your flight, and it competed with the local shops, the local shops, and ultimately the beauty perfectionist is not something that you need to trouble yourself with. It's just that the defendants, so the respondents rely upon that as being an appropriately fair specification, but it was based on its own facts and its own evidence. Ultimately, there's a sort of humorous example given by in the academic commentary in this area, which is that you are not concerned with trimming a mark down to 3-hole razor blades coming from Venezuela, because in fact that's the only sales that have been made. The idea is that you can go over specific if you're not careful, and it's actually inappropriate because a trademark has a function to protect a penumbra around the actual use made, and in many cases the use that's being made, especially if something like retail services or advertising services, it's very easy to just simply regard that as a paradigm use of it. EasyJet, the use shown was of retail of a large number of goods. Okay, it wasn't selling sporting equipment, but it was selling largely gift items and cosmetics, so on, alcohol, I think. So, but the point is, you don't trouble with the retail services part of the specification. If there is some narrowing to be done, you can potentially remove some aspects of the actual trade, but provided that's actually properly made out. But even then, it's difficult because the retail service itself comprises the bringing together for the selection and convenience of customers of various items and is quite distinct from the underlying trade in the items. So when you have a trade that is competing with other retailers at that level, then we say they should be just left with retail services in just the same way that the other traders are. So the final, there's just one other little point on the in-flight, which comes up in our reply skeleton at tab 8. I could just probably just turn that up. And that's because the judge himself used the words in-flight, but he only did so as a sort of shorthand for what he was talking about, which was airline passengers. It's just important that my lords have that clearly in mind. It's paragraph 7.1 and 7.2, page 92. Sorry, that's the Bacon analysis. And it's using it in an extended sense to indicate services provided other than in flight. You can see that from top of page 93. Yeah, sorry, this is not Bacon, Joe. Sorry, that's what I thought was my original. This is the judge in this case saying that the extended use simply referring to in flight is using it in a sort of extended sense defined in the judgment to indicate services provided other than in-flight. That's why the judge did not adopt the in-flight language, because, and rightly so, because had he done so, he would be using a term in a trademark specification, which is for general public consumption, and people who've never read his judgment, which is being defined in a particular way in the judgment. But he didn't do that. The reason I mention this is because this is something contended for in the respondent's notice. We say that would be wrong, and all of the points we make about fair specification are fortiori in relation to the in-flight parallel. So the last revocation ground relates to easy.com, and that relates to email services. Ground 4. The trademark is. Is it? I'm being reminded of whether the shorthand writers might want to.
No, we'll carry on. We haven't finished. I'll decide when we have the break with respect. Yes, ground 4.
Ground 4, easy.com. This ground of appeal concerns total revocation. So this is a total wipeout of the mark. A mark which had been used for email services. There's no question about that. It had been used for email services. Or at least it appeared to be common ground that the services were provided to a substantial extent, although that is now come in by way of a respondent's notice as something that is not. It is said, the reason it wasn't genuine use is because it was used as an illegitimate promotional tool for other goods and services, not email services. So the email service, which is a facility for sending and receiving email, existed, but it was, say the respondents, akin to a piece of merchandise, merch, email as merch, the sort of thing that if I visit my solicitors in this case and come away with one of their pens saying Stevenson Harwood, it can be said that that's not use in relation to stationery because it does not compete with Ryman's in the stationery market. It's just a way of solicitors' firm getting their legal services name about. That's the argument that was made by the respondents and accepted by the judge. It's a giveaway item. Now, I mean, before we look at the authorities, it really is quite astonishing for email services to be characterized in that way. And it's also unsurprising that email services, or the actual provision of an email address, was not distinctly and specifically charged for. I don't think I've ever paid for an email address in my life. Certainly Gmail and Hotmail and all the rest of them, and Yahoo Mail are all available. Free at the point of use. Maybe you pay in other ways, data and what have you. But it's quite a surprising thing to characterize email services as some sort of, as akin to a piece of merchandise. Now, can I please ask you to look at the Silverhill case, which is in your authorities. This is the wellness case about drinks. Tab 8, bundle 1, and it's going to be looking at only a couple of paragraphs. Paragraph 8 and 20.
Yeah, tab 8.
Tab 8, and it's paragraph 8, well, paragraph 7, page 151, and it's paragraph 7 and 8, 20th. Paragraph 7 and 8 simply state the facts to remind you of what the case was about. It's an undertaking that manufactures and sells clothing. It owns the word mark wellness, which is registered in the Austrian Patent Office, registered for Class 16, which covered printed matter, Class 25, which included clothing, and Class 32, which covers alcohol-free drinks. And in the context of the sale of its clothing, Maselli used its mark to designate an alcohol-free drink, which was handed out as a gift in bottles marked wellness drink. along with the clothing sold. In its promotional document, Maselli made reference to the free gifts labelled with the wellness mark. Now, starting point there is that we're not dealing with a good, we're dealing with a service. It's quite difficult to, I suppose it's not impossible to think of a service as merchandise, but we say that's quite a surprising thing. These are not inherently promotional items at all.
Before we get on to your submissions on the present case, let's finish off with the statement of principle from Silberquella, shall we?
I was going to, yes, and that would be, if you look at, is it paragraph 19 and 20? As the Commission submitted in its observations to the Court, and as the Advocate General stated in points 45 and 55, it's essential in the light of the number of marks that are registered and the conflicts that are likely to arise between them to maintain the rights conferred by a mark for a given class of goods only where that mark has been used on the market for goods or services belonging to that class. For the reasons set out in points 48 and 56 of the opinion, so there's quite heavy reliance on Advocate General's opinion, that condition is not fulfilled where promotional items are handed out as a reward for the purchase of other goods and to encourage the sale of the latter. So what we have there is quite a narrowly defined situation in my submission. We're dealing with a good, which we say is quite specific. So certain kinds of goods are inherently better suited to being promotional giveaways upon the purchase of other goods. But secondly, that's not what happened here. There's just no evidence of that happening here. This was not, you didn't get an email address when you hired an Easy rent-a-car or took an EasyJet flight. The fact that the evidence was that EasyJet hoped that people would, it was a webmail-based system, so it didn't use your local server or your local client. You had to log in to the EasyGroup website to get your mail, which meant that you transacted, you looked at the website, which is a good thing. EasyGroup were happy with that. Cross-selling. We don't deny that the part of the function of these email services was cross-selling. That's not an unusual thing for businesses to offer you one thing and want to offer you another. That does not turn it into sort of a Silberquella case, which is where the product really has no commercial value as a genuine use for those products, for the products that it is, and is purely merchandise, purely promotional. That is just not what happened here. What the respondents have done is they've taken our evidence where we said this was going on. We eventually took the email services in-house and started using the emails ourselves, and this all petered out. But for a time, there were people, it got people to visit the EasyGroup site, and that was a jolly good thing. Maybe they would transact on with other services that EasyGroup offered. That is just miles from being anything like Silberquella, and it's a great exercise in ex post facto reasoning as well, and it just simply does not sit well with the email services, what they actually are, which is a fairly functional service, ability to send and receive emails that does not have anything to do with other goods and services, save for the purpose of cross-selling, which of course we accept. We cross-sell against all of the other EasyGroup businesses. That's part of the business model. Now, the respondent's notice on this was to say that the judge should have completely revoked easy.com for email services because there was no evidence of the numbers. She's right about the fact that there being no concrete evidence of the numbers of email services supplied. But it's interesting to note that when they were arguing the promotional argument, there was no question about there being significant quantities, because of course it was part and parcel of promoting as you want to be distributing. So there wasn't a question being raised about that. It's only in circumstances where the promotional argument has failed and they're scrapping around looking for another argument that they say, well, there wasn't sufficient evidence of the numbers. But the argument is bad on its own account for the following reason. When it comes to the assessment of
Sorry,
evidence,
what was the judge's finding?
the
What was
judge,
a
the
good
judge didn't
starting
find, the judge did not find that there was inadequate evidence of numbers. He just didn't trouble with it. So I understand that's
Yeah,
right.
but what finding did he make? I mean, I
Uh,
appreciate
Yes,
that's why there's a respondent's notice,
Yeah.
because they're saying
Exactly.
there's he's either wrong or he's made an omission. But we'll put that argument in context. One needs to start with what he actually did say.
Yeah. So. So the judge, we say, on the invitation of the respondents, really went in and analysed the promotional argument as
Well,
being the reasons.
you've explained that already.
Yeah,
You've got
yeah.
that. We're now on to the respondent's notice point.
Yeah. And the
And I
respondent,
appreciate that you're trying to anticipate an argument that has not yet been opened by Ms Hemsworth.
Yes.
But even so, given that you raised it, it's helpful if you could point us to the relevant paragraph in the judgment.
well, he didn't. So the only part of the judgment dealing with easy.com is where he's dealing with the it's
148 to
revoked.
153, the paragraph.
So he's dealing with the promotional argument. And as we read that, we did not see any, he does note that no evidence of quantity was given in 149, if there's any, but that's not a problem for him. He doesn't refuse it, he doesn't revoke it on that basis. He just notes that there's no evidence of quantity. But there's nothing particularly damning about that. It's often the case that you don't have, I mean, it's slightly surprising for email addresses for there not to be that data, I get that, I've said that. But there are many businesses where there will not be exact numbers. And we say that there was at least inferential material, even on the judge's analysis. This was getting people to log on to the EasyGroup site, the home page, and the evidence is that it was top of the page. Clearly it was something commercially worthwhile doing for a time. But if you don't have that data, and it's true, but there's no requirement that you have any particular form of evidence in order to make the assessment. We say that there was ample material to make the
So
assessment.
your point is it's not de minimis.
It's not de minimis.
I mean,
Exactly.
Yeah, we're not allowed to apply de minimis threshold anyway as a matter of law, but
Right. Yeah.
even if we could,
Even
say
if you
it's not.
could, it's not de minimis. There's no suggestion that it is, and it's a new suggestion that it is now, because it was always assumed that there was a promotional activity going on, which again suggests that it's not de minimis, at least in those terms. So I think on the grounds revocation,
I was
Those
going
are-
to say, does that deal with revocation?
I think it does.
Right, fine. Okay, well, we'll have the 5 minutes for the transcribers now.
So let me- You just saying just remind. I've still got my dimensions a bit wrong. It's really big towards us. It's like a mind map. I wanted to show Emma my mind map. So I did a mind map. I know you like mind maps, don't you? It's a little bit messy for you.
About that.
Court rise if please.
I should have probably said yesterday, and I certainly should have said at the start of this morning, that if people are very hot, they can take their wigs off. I must say, thus far, you have it on my authority, this is the coolest room in the whole building. I don't know how we've achieved that.
I was going to say,
And of course, you know, who knows by the time of this afternoon, but at the moment, it seems to me to be relatively comfortable in here.
great. Well, that's our experience as well.
Right, so we're now going to the infringement grounds.
We're going to the infringement grounds. Just a couple of prefatory remarks there. The infringement grounds comprise three issues. First of all, decisions that need to be taken again by this court, we say, because the error of approach was so fundamental that the conclusion is vitiated. Group two is decisions that would need to be taken by this court in any event because no finding was reached. And then group three would be decisions that might need to be revisited or that do need to be revisited if my lords are with us on any of the previous arguments made this morning on revocation.
Yeah.
Because the scale gets, or the slider moves closer towards infringement. If the goods are identical, so the services are identical, then they are. If they are pared away and shackled away in a restricted way, so that's a sort of obviously there's going to be, on our case, a large number of decisions on fact that need to be made. I was going to say this to my lords, which is that is not an ideal scenario to be asking the Court of Appeal to reach this many factual findings in a trademark case. It does sometimes happen. The decision needs to be taken on maybe one or two issues, but this might be more than that. And I should say my learned friend seems to agree that there will have to be retaking of decisions. She says in her favour, as the judge reached, but if there she says they don't make, our submissions don't make any difference, but I don't think it's actually denied that there might be a degree of, an unusual degree of primary fact finding that is necessary, and that's not an ideal scenario.
Well, it's not primary fact finding, it's evaluation on the basis of the facts found by the judge.
That is so. I suppose what it means is that we've got, if you're the losing party, let's assume against ourselves at the moment, in the final determination, we've lost a tier of the court
But
system.
that's always true when this court retakes an evaluative decision.
I accept that, of course, but what I mean is the number of decisions in this case is
But
basically
it
the
can't
same.
affect the principle.
No,
Um,
I suppose not.
On the other hand, it's recognised that it's not always appropriate for this court to retake an evaluative decision. Sometimes it's more appropriate to remit it to first instance. So are you submitting that this is such a case?
I'm submitting that it's something that my lords may consider, because and my lords are in a better position than I am as to know how the various levers get organised in the final analysis. But just because if the court were on our case to make all of these findings again, one party or the other is going to be pretty upset, I would have thought, and not going to be happy with the idea that they've not that they trust my
the
lords,
parties
but that
might
they,
be even more upset at the need for yet another hearing.
that's never ideal. But it is simply something I really leave to my lords, and I just flag. I wasn't necessarily contending for that result, really just to flag it as an issue. The second sort of introductory point I wanted to raise, which is this: my lords will be aware that on the Easy Funding site, there has been and still is at various times extensive promotion of retail services, extensive promotion of services in the travel industry, including in the past, EasyJet itself, Easy Hotel, and so on. And so we say that in the ordinary course of using these signs, Easy Fundraising, certainly not undertaking not to, there have been and will be travel promotions taking place, and there will be holidays and hotels, all the things that, if the Easy Group companies and the core ones are known for nothing else, it's really for those travel services. Now, that's not something that we say the court should ignore. It might be suggested that somehow, I've got extensive citations in the bundle of examples of that, and it might be more convenient to just provide that afterwards, or I can give you some examples. But I don't think it's disputed that that has taken place, and it might be suggested that that's somehow not use of the sign that's causing the infringement, or that's not relevant. But we say it is highly relevant. It is part of the ordinary use of this sign that it will be and is used in relation to things that aren't necessarily in the specifications that we're relying upon, but nevertheless make confusion more likely. And
Right, so can I be clear as to the point you are making? Because at the moment, the way I'm understanding it is this is context of the sign
that's probably
in the infringement analysis.
I think we
And
can't
the
raise it.
argument is, I mean, context in the infringement analysis is often used by defendants to try and negate a likelihood of confusion that would otherwise exist.
Yes.
But conceptually, one could argue it the other way around and say that context can increase the likelihood of confusion, although whether it's capable of producing a likelihood of confusion if there's no likelihood of confusion anyway, may be open to debate.
It might be said it's more suited to a borderline
I mean,
case.
as I recall, that point was left open in the Morlitz case.
Right. Yes.
But at any rate, if I've understood correctly, what you're arguing to us at the moment is that this is a case where context exacerbates
Yes.
likelihood of confusion.
We do say that, and
Do
although
you go so far as to say it produces a likelihood of confusion even if there is otherwise none, and is that legally open to you if that is your argument?
We don't say it produces a confusion when there's otherwise none. So, because otherwise booking.com, offering whatever, easy hotels could lead to confusion. So we're not saying that there is already a propensity for confusion, and the court is dealing with likelihood, and that can be realised in circumstances where they are trading in particular areas which are associated with the core businesses on the claimant side. We say that it can't exonerate but not exacerbate. It must do either neither or both as a matter of principle, because the only objection can be, well, it's not the sign that's causing the problem, it's something else. It's outside the sign. You can get them for passing off or something, but not for the use of the trademark infringement. But we say that it is perfectly legitimate to take account of context wherever that leads. And in this case, we say it leads in an exacerbation direction. So, I mean, I've got a long list of examples of that. I mean, it's not just the use of EasyJet, it's just the use of airlines, several airlines and travel companies and others that, because I think the EasyJet or the specific uses of easy companies has ceased for some unknown reason. Obviously, it could be controlled and was controlled, I guess. That must be the only reason. I think it comes through a lot of the trade from the defendants comes through the affiliate marketing program, not directly from the businesses, but through affiliates who use them as a marketing tool to gain affiliate income. But anyway, the EasyGroup uses have ceased, as far as we know, whereas the travel and airline offerings are still going apace. When it comes to the business of the defendants, of course, I must also make a point about what that business is. The starting point is that the defendants, whilst they are no doubt contributing to the greater good in the world by devoting part of their income to good causes nominated by the users of their site, they are a commercial entity that takes 50% of the commission on sales for themselves. And they operate completely profitably and for profit and are backed by venture capitalists and so on. So that's the first thing. The second thing is the judge conceived of them as only providing a service to the retail services that are offered on the site. And that service was said to be advertising only. Because when it came to the service that it provides to consumers, that seemed to be out of scope. And we say that the service that was provided to consumers was a very clear one, and it was the retailing of services. The retailing of services, not the retailing of goods, but the retailing of services. And once you conceive of their business in its correct framework, we say it's providing a retail service. And that's very similar, if not identical, to our retail services in whatever form they're left in, but certainly in their full scope. And the reason we say that is because there was in the judgment a long exploration of whether somehow the business itself was involved in the underlying trade in goods or services that are offered and advertised on the site. And the judge gave that careful consideration and rejected it for a number of reasons. First of all, there was an interstitial page, so a consumer wanting to buy those goods would hit the John Lewis page, you are leaving the site, and they would buy them from John Lewis. And although there were some infelicitous mentions of the word partnership here and there, it wasn't a partnership. It was simply a case of the Easy Fundraising Company promoting or advertising the services, the retail services that were on their site. So we agree that that form of activity was taking place, but that was the service that was provided to the retailers. That failed in the confusion analysis because they were all traders who were deemed to be sophisticated and careful and not easily confused. They know who they're dealing with. They didn't think it was EasyJet or EasyLife or anybody else. And one can well see that the judge's judgment in that regard is, at least we say, has some foundational basis, although we say that is still wrong in the light of our, hopefully, correct submissions on the revocations, some of the revocation issues. But where we say there was a bit of a blind spot, well, a significant blind spot, was to consider what was being provided to consumers. This is fundamentally a service for consumers, or at least purports to be. And, of course, they're making profit in the background, no doubt the retailers as well. But from the consumer's perspective, this is a way to give to charities, good causes, by shopping. And this is a service, a valuable service, as far as they're concerned, that Easy Fundraising are providing. And what is that service? Well, that service is the bringing together, for the benefit of consumers, a large number of retail services of goods and services. So it's retailing services. Now, to the extent, I don't think I need any authority for this proposition, but to the extent it's necessary to, you will have seen the Netto marketing case that was referred to, that came into the bundle yesterday. Not come into the bundle. Oh.
Used to me.
Right, okay, sorry, so we've got copies of it. What I'll do is I'll just...
So there weren't enough authorities in the 5 bundles.
My Lord knew that that's entirely typical in trademark appeals. It is really remarkable. Sorry, can I have one more? Sorry, I was just checking whether my learned friend had been notified about this. So on the live link yesterday, I saw Mr. Aikens addressing the court on the Practica Bow case, which is the sort of classic retail services judgment reference from the European Court. This was a little bit later. And it's not really authority for a proposition, it's really just to show you that such things as retail services of services are known to the law and understood. So this was a German trademark application, Netto Mark and Discount, in Class 35, the service of bringing together services. Registrability, meaning of word services, application refers to the ministeriality. And you can see that what happened was, it was questioned whether this could be a trademark or a proper specification, and held that it could be. So I think probably the head note will suffice. You've got the Class 35 application with the specification in the 3rd paragraph of the head note. I mean, the head note is I was going to say the second question is also, it was H16, it's unnecessary for the person applying for registration of a mark with respect to bringing together services to specify in detail each of the activities making up that service, and a description such as that in Netto's application would allow both competent authorities and economic operators to understand that the application was made in respect of a service which consisted in selecting and offering an assortment of services so that the consumer could choose between them from a single point of contact. Now, the reason I mentioned that point is because, as we understood the submission made yesterday, obviously it could have been against a different factual background, which I'm not fully aware. But if and to the extent is suggested that the sale needs to be made by the retailer, that's not required. Because the fundamental quality of a retail service, and one which comprises the bringing together of other services, is the bringing together aspect, the selection, the fact that these are the ones that matter. And in a case such as this, that really is the position in spades, because all of these retailers have indicated they're prepared to give percentage to charity, and they're registered, and they work with this interstitial page, and they pay back commission to the vendor. So it's a finite group, a large but finite group, and getting them together and putting them on the site, making sure they're all in one place. Sometimes there's a retailer of the week and that sort of thing. I noticed the judge we talked about. There is some value in that service. And so that's, we say, quite an important introductory point when it comes to the assessment of infringement, when it comes to the court's final assessment of the infringement questions. So with that introduction, what I propose to do is actually, the grounds of appeal on infringement are relatively short. I should be able to take them in fairly short order. So the first ground 5, is that the judge approached, and ground 5 you'll recall is the Easy Life second mark. It's too young to be revoked. So it's just a pure infringement question. And there were errors in the judge's 10.2 and 10.3 assessment. What I mean by that is likelihood of confusion assessment and the unfair advantage, detriment to the distinctive character or repute, which actually has no sphere of application that's separate to section 10.2 in this case.
So we can just focus on 10.2.
You can just focus on 10.2. The point here is actually made pretty clearly in the passage of the judgment extracted below 77.1 of our skeleton. And it is an easy mistake to make, but it is a mistake.
It's always helpful to look at it in context in the judgment. So can you
Sorry,
give
my
us the
lord,
judgment?
it's paragraph 257, yeah. Page 158, tab 10. This is the trademark that we own protects goods and services in the form shown on the register, not the particular commercial variation or use that we have made. Otherwise, you're left with a situation where the more you use a mark, the less protection you have. So it's just a wrong approach. And trademark lawyers often talk in terms of you've got to adopt a notional and fair use of the mark in the form as registered. So you read those services, whether they be retail services or advertising services, promotional services, and they are in that form. You ask yourself, is what is being provided, does it fall within those words? If it falls within the boundaries of the monopoly, it's an infringement. Well, sorry, it is identical. If it is similar to the bounds of the monopoly, it's similar. Both of those findings are relevant to the overall assessment of the likelihood of confusion.
So you say the error is in comparing the services actually provided
Yes.
by the relevant to passing off, but it's
Correct.
not correct for a trademark infringement.
And we say this is at the core of this analysis, and it's one that vitiates the overall conclusion. Same error, paragraph
257 does say, as regards the online and mail order retail services that are part of its specification.
Yes, but but then those are not, those don't have the colour and character that the judge plugged into the question. So they do fall with what we've been providing is obviously within our own specification, but ours is more general than that, and it's that that needs to be compared. Otherwise, you're distracted by the specifics of the use that we've made. Sorry, 258 and 259 with the additional paragraphs that say the same thing, or more or less the same thing. Maybe it's the same error.
So that's under the heading of risk of confusion.
Yeah. So that's ground 5. Ground 6 relates to the first Easy Life mark, and this was a case in which there was no finding at all. I have this right. So there just needs to be a finding. So in some cases, the judge went, well, if I'm wrong about, for example, the variant use, he said, if I'm wrong on variant use, I'm going to go on and consider the services and whether I need to tweak those. But in this case, he did not, having found against us on both of the revocation questions, did not think it appropriate to reach findings. And sometimes judges do, sometimes they don't. But this one is a case where the judge didn't, and if we're right in restoring mark, then there'll need to be that finding. Yes. That's right. So there's a little bit of reasoning, is that's what I'm saying? There's a little bit of reasoning because the judge said it fails for the same reasons as the other Easy Life mark. So there is that.
Where's that?
225.
2,
Paragraph 225.
225.
Round 7.
So 225 is in
Little bit
the
of
section
reasoning.
of the judgment, again under risk of confusion, but this time in relation to and the name of
The
it.
first Easy Life mark where he reads across the reasoning from the second.
Yes.
So, sorry, that's not the same as making no findings.
Yes, exactly. So it's a smidgen of reasoning, we say. It's inadequate reasoning because, of course, the second Easy Life mark is too young to be revoked, and he has revoked the first one. So, I mean, it might be said to be wrong in our favour because he is. Oh, I see. Yes, right. Okay. So, in fact, it's vitiated by the same error. So we should have a look at those paragraphs. Okay. 258, 259, yeah. Yes. So, yes, the point raised by my learned junior is quite right, which is that when the judge is dealing with 257, 258, dealing with the other Easy Life mark, he's also making the same error of looking at the actual use. So he refers in 257 to the website from which various products can be purchased directly from it. There is therefore some similarity, but only a fairly high level. And again, that is delving too much into. Really, the question is, what do Easy Fundraising do, and does that fall within the wording of the trademark? That's the question.
This is ground 5, isn't it?
Yes.
Yeah. So just so I get this clear, the judge did make findings. There was no infringement of the Easy Life word mark. Did he?
Yes.
Yes. And there's no specific complaint against that other than your ground 5.
Ground 5, which is that he made the errors of the. He was distracted by the actual.
And your ground 6 is he made a finding in relation to the Easy Life trademark, stylised mark.
Yeah.
But only did so by cross-reference to the findings he'd made in relation to the word mark.
Yes. So the end of paragraph 259, I'm asked to show my lord. Yeah. The average consumer would not like to be context. And then 7 is the sliding scale point about airline passengers. So that would have to be retaken, because if we're right about airline passengers wrongly being imposed upon our specification, that might lead to a different result in around 7. I think that's the only point. 7, but I'll give a shout if I'm wrong about that.
Well, insofar as it's affected by that point, understood, but I thought your ground of appeal extended beyond that.
Yes, it does, because of the netto market point. Does my lord mean? Yes. So we're now dealing with retail against retail. Retailing of services in the case of EasyFundraising versus the retail services mark contained in the second EasyJet mark.
Yeah, so your first point is he was wrong to restrict your specification to airline passengers.
Yeah.
And that has knock-on consequences for the infringement analysis. And your second point is your retailing of retail services point.
Yes. And I'll say, we say that retailing of goods is identical to retailing of services. But if it's not, it's highly similar. And obviously, the more weight that is given to that question, the 2 factors that are most significant when it comes to the assessment of likelihood of confusion are the degree of similarity between marks, the degree of similarity between goods services. This one, we say the second of those would shift significantly, but also when it comes to retail services, there's a big shift about the relevant consumer, because the judge looked at things from the advertiser, the sophisticated advertiser client of EasyFundraising, their point of view, whereas now the attention turns on members of the public and what they make of the EasyFundraising site. Ground 8. The colour point, yeah. There was a further point when it came to the overall assessment, which we'd ask my lords to bear in mind and not repeat when it comes to any determination, which is that the judge again made an error that has been made by other judges in this area of law. And it's somewhat understandable, but it is still wrong, which is that when you have a mark which is registered for a word alone, or in monochrome, but typically for a word alone, it is not right to look at the colour that has been made, the coloured use that has been made of it. Now I say that subject to a couple of qualifications. It can help a party who has a registered trademark not in colour, if he's always used it in colour, and that's helpful to an infringement analysis. The Specsavers case is an example of that, where I sort of assisted in the overall infringement analysis to some degree. Actually, it turned out Asda were also using green, had a sort of right to use green. But leaving that aside, what it can't do is inhibit the action, because of course then what you are doing is you're allowing more use made by the trademark proprietor to actually impair infringement, make it less likely or reduce the scope of protection. When it comes to this case specifically, we had marks, the EasyGroup mark was in colour, a couple of the secondary marks were in colour, but the ones that we're concerned with, colour was irrelevant because they were either word marks or black and white marks, Easy Life. And therefore, it isn't right to say, well, they're always used in orange and white, EasyJet for example, and that is absent from EasyFundraising's use, and therefore that's a point in their favour. Now, it's difficult to assess quite how significant that was in the judge's analysis. He definitely does carry out that analysis in a couple of places in the judgment, but all we would ask for is that that not be conducted in the same way by my lords, who will hopefully approach this on the basis that there are word marks, there are simple device marks, and none of them, the colour is relevant.
So, translating that into language I can understand, do I understand you to mean that this is not an independent ground of appeal, but it's an error that needs to be corrected by this court upon a reassessment?
That's right, Lord, yeah. And then ground 8, which is the easy.com mark. This was another one where there was a failure to find, and that's right this time, it wasn't any reading across some other bits of the decision. A failure to find in relation to easy.com. These were the email addresses that were given away as merchandise effectively in the judge's view, and therefore it wasn't necessary to consider their infringement. And we say if that's reinstated, then that will need to be the subject of further findings. Lords, Mr. St. Quintin's was going to address you on the invalidity arguments, but I don't know what had been discussed in relation to the order of play on that.
That comes in response to
The response
this.
only,
That's
yeah,
the
yeah,
application.
understood. Is there anything? Yeah, yeah.
Sorry. My lords, with your leave, if I may address you, you may be aware that there's an application's been made for certain unagreed documents to be looked at. To explain first the context in which they arise, they are all documents that were before the judge that he summarised to some extent in his judgment in the annex to it. And they only arise for your lordship's consideration if it comes about that you're going to reconsider questions of infringement. So they are some points that EasyGroup wishes to rely on that come from those documents that submit assist the finding of likelihood of confusion that we argue for.
Well, we don't know whether we'll be reassessing infringement. So the usual course that we take is to look at any documents that anybody wants to show us to Benes.
Well, I'm grateful, my lord. In that case, it may be that I don't advance the application. It may be sensible then if I make submissions about those documents and the reasons why they're
Yes, but it would be more sensible if you first identified which point this goes to.
Yeah, my lord, of course. So these documents go to the assessment of likelihood of confusion. We say that they are examples of mistakes being made by people, and that mistake being indicative of a reliance on the easy aspect of signs used by defendants and of trademarks relied upon by my clients. And that indicates, it's a relatively small point, but it indicates in our submission that the easy aspect of those marks is something of particular distinctiveness and has particular relevance in giving rise to a likelihood of confusion.
But sorry, is this? It's entirely my fault, I'm sure. Is this this isn't a ground of appeal?
It isn't a ground of isn't a separate ground of appeal, my lord. No, it's an aspect of the reassessment of the likelihood of confusion if that comes about as a consequence of the grounds of appeal that have been advanced.
Yeah, but
Yeah, I mean, it's usual to give some sort of notice of that. Where do I find that in the extensive documentation?
There is not, beyond the application notice that points to the particular documents in the unagreed bundle, there is not any.
That's the application notice in relation to the documents.
Correct, my lord. But there is not in the written materials other identification of this point as arising in respect of the likelihood of confusion. To explain why that has arisen, the approach taken was to get to the stage where this court reassesses the question of likelihood of confusion, of course, was incumbent upon my clients to establish an error of principle or another basis on which this court could interfere or reassess the questions of likelihood of confusion.
But do you say that is there any reason why we can't be simply guided by what the judge said about risk of confusion?
So the only point arise is that in some of the judge's summaries, we don't criticise that he made a summary. Of course, the judge gave a proper indication of what he had looked at, but some of his summaries don't show all of the details of the documents, and there are aspects of them, particularly 2 of the 3 aspects of them, that we would seek to rely on to show the importance of the assessment that
Okay, well, why don't we start by looking at what the judge said?
Of course. So you find this in the annex to the judge's judgment, which is right at the end of tab 10, beginning on page 182 of the bundle.
So this is the schedule with the alleged ventilation
Sorry,
system.
yes, apologies. I've referred to it as an annex, but the judge calls it the schedule. So it's the very end of the decision. There are 8 examples there. I don't intend to take you through all 8 of them. Some of them I can't take any points from. In respect of 5 of them, I say, even notwithstanding the fact that we do not dispute the judge's rejection theories as instances of actual confusion, we say they are still examples that can support a proposition that the easy element of the marks is important. So that is the full extent of the point that's made, relying on it.
Right.
And if I may very briefly go through them.
Just wait.
No,
Okay, well, you can go ahead with this, but I think it should be brief, given that it's not an appeal against any of the parts of the schedule.
Well,
And really, it's just identifying the particular points that, as you say, show that the easy element of the mark is important.
Of course. So I won't stress you on the first entry, so no additional reliance is placed on, them in this appeal. In respect of the second example, this is not one in which there's an additional document, because we're satisfied that everything that could be taken from those documents is summarised in the annex.
Yeah.
The point that arises is that in the penultimate paragraph of this section 2, the paragraph that begins again, the judge identifies various possibilities of what this example might actually indicate, which could be a simple misdirection of an inquiry, or it may be the consumer used Easy Fundraising and thought it could be used as a means of contacting Easy Life, as Easy Life had a retailer page, or indeed that CDRL, so an entity that had been contacted by Mrs. Halliwell, forwarded the first chaser email to the wrong address. So the only point to be taken from this is that it appears there was some form of mistake. The circumstances in which that mistake may have arisen, we say, are best explained by a person, Mrs. Halliwell or CDRL, relying on the common easy element of Easy Fundraising and Easy Life as an indicator that the businesses were either the same or connected. So that's the only point I take from 2. From 3, the 3 is one in which there's an additional document on which we would seek to rely. The only purpose of the additional document is it shows Mr. Harley, who's discussed in this paragraph, Mr. Harley's initial email. It is clear that Mr. Harley made some form of mistake, because it was accepted by the judge that he wanted to contact EasyJet, but used the Easy UK handle. the Easy UK handle is a sign that allegedly infringes the Easy Life stylized mark. So I must make that clear that this is a question about EasyJet. So this is an example about a confusion of EasyJet, but I'm relying on it in respect of Easy Life stylized. But whatever the basis of Mr. Harley's error, and accepting that he may not have had the level of attention to detail of the average consumer, we say it is evidence supportive of easy being the aspect that's relied upon by certainly this consumer, and we would say consumers generally, to identify the origin of businesses. The only purpose of the additional document was that it actually showed Mr. Harley's purpose in contacting EasyJet.
Well, let's look at it and see. shall we?
Well, I'm grateful. So you should have an unagreed documents bundle. Which has only 10 pages. Mr. Harley's post is on page 6. It's the second tab. And the point I take from this is that Mr. Harley was seeking to contact EasyJet because, well, one, he wanted to say he enjoyed his flight, but in his second sentence, I left a stamped addressed birthday card on the seat on the seat pocket in 31D.
Yeah.
To contact them. So there was obviously something important to Mr. Harley making the contact for, yet he made that mistake. That is the short point that comes from that additional document.
Which he accepted in the second email, which the judge cites.
Yes. Yes, he obviously recognised once he'd been contacted by EasyFundraising that he had made a mistake. And the judge held, and we don't challenge this, that may be an example of him not using, paying the correct level of attention to detail, but it is still a question of the mistake being made and the reasons for that, which EasyGroup would rely upon. Given your Lordship's indication about time, I'll only take one more example from the annex, and that's example 8. This is the subject of another set of documents. So in example 8, there was communication between Joanna Trokimiuk, apologies to her if I pronounced that incorrectly. She had been emailing the Chief Customer Officer, Miss Heasley of Easy Fundraising, in emails headed EasyGroup Report, and I'll summarise generally, seeking to sell services to Miss Heasley about EasyGroup. And Miss Heasley's ultimate response after these chases was, "We're not part of the EasyGroup." There were explanations for that, which the judge explored, but his ultimate reason for rejecting this as an example of actual confusion appears at the end of the penultimate paragraph of this section, which is that it may be that Ms. Trokimiuk thought that Easy Fundraising and EasyGroup were connected, and this is evidence of indirect confusion. However, Brand 24, this is Ms. Trokimiuk's company, is a media analytics company seeking to sell its products, is not a part of the relevant public. And further, it was based on perusal of data not available to the average consumer. And so the only point I take and can take from this is to submit that regardless of Ms. Trokimiuk not being part of the relevant public, therefore not being indicative directly of the average consumer, nevertheless it does appear that a mistake was made, or at least she considered that Miss Heasley would be interested in reports about EasyGroup. My submission, the most likely explanation for that mistake is the common easy element, which is a factor in all of the infringement allegations. So, my Lordships, those are all the submissions I wish to make on that annex and those additional documents, particularly given your indications about the time.
Right.
So what about the third document?
So,
which instance does that
So
relate
the
to?
third document relates to instance 7. The purpose of including that is a very short one, which is that in instance 7, the judge described an image. We thought it may be useful to provide the image. It's not an example I've made submissions about to you, given the time. It's
Okay, so
the
the
other two are
help us raise free donations. That is the document he cites in item 7, and you're showing us this document at page 8 of the unagreed bundle.
My lords, yes. That 7th instance is not as strong as some of the others I've referred you to. Given the indication from the bench, I will stop there unless I can assist you further.
Okay. Thank you very much, Richard. Thank you very much. Yes, Ms Himsworth, 1:45 is never a very good time to get going, but I shall ask you to get going nonetheless.
Certainly, my lord. My lord, perhaps as we have just been dealing with it, I could just make a few comments in relation to the application that was made
Yeah.
by my learned friend,
Yeah.
whilst it's fresh in everyone's mind. The first thing to make clear is that the admission of these documents was not agreed, and for good reason, and was explained in correspondence, some of which I hope will have made its way to the court. If it hasn't, I'll ensure that my lords have copies of it. But in
All we got is the bundle itself.
you've got the bundle itself. Perhaps if I could just hand up the copies of the document, the letter that was sent.
Would you want us to tell us?
I'll simply tell
If
you.
it's
probably
solicitor's
much
correspondence,
easier.
I'd much rather you told us.
Right,
than
well, I should
I
just tell you.
waded through
um,
3 pages of hyperbole.
I'm glad that's only one page, but anyway, I should just simply tell you. Basically, it's resisted for the reason that my lords, between my lords, raised, which is first of all, these are documents that are not relevant to the appeal that's been advanced before my lords.
Well, it's not suggested they're relevant to the grounds of appeal. What's suggested is that they're relevant in the event of reconsideration.
Well, my lord, that's not the way that it's ever been said prior to in court today.
That's
and
what's said now.
it is what is said now. I agree, my lord, but it's not said that the judge erred in his findings that these were not examples of evidence of confusion.
Yeah, but this is the point that comes up repeatedly in this context, which is evidence may not be evidence of actual confusion, but may nevertheless be evidence of a propensity for confusion or a risk of confusion.
That may be
That's what's said. So it's accepted that these are not evidence of actual instances of relevant confusion. What's said is this is evidence which supports the proposition there's a risk.
Well, my lord, I will be making submissions in the context more generally of what I have to say about the scope of the disclosure exercise, of which these are just a small number. The second point I would make is that one must remember which are the trademarks that are being relied on in this case, none of which are easy solus. And my learned friend was referring simply to confusion as a result of the use of the word easy, the easy element.
To be sure. So what you're now telling us is you have answers on the merits.
Yes, my lord.
But why does that mean that we don't look at the documents?
My lord, it's simply that the summaries contained in the judgments are sufficient for these purposes.
Okay.
Yes, and of course it's on the basis. I mean, the judge has made evaluations in his judgment in relation to these documents.
If there's to be a re-evaluation. If there's to be a
Yes. And my lord has already indicated that if there is to be a re-evaluation, it needs to be on the basis of the facts as found by the learned judge below.
Primary facts, to be sure.
Primary facts, my lord.
Well, why does that stop us looking at the documents that the judge has looked at?
Because my lord, the judge has already made findings specifically on those documents, which are recorded in the judgment, and they're not challenged.
It's the finding of no actual relevant confusion is not challenged. There still has to be an assessment of the risk of confusion.
But
If the grounds of appeal succeed.
But again, my lord, this is not a specific, this is not mentioned in the ground of appeal as to a point that my lord should open
It's
up.
not, because
And
it only arises if the ground of appeal succeeds, and therefore there has to be a re-evaluation by this court. And if there's to be a re-evaluation of this court, why should we not look at the same documents the judge looked at?
Well, I hear my lord has seen only two documents relied on in that category.
See everything else.
And but that my lord is not being
So
shown
it's not as if we're doing, there's an objection on the basis of weight of numbers.
Well, my lord, there is an objection in relation to that, and I'll come back to that, because these are just 8 instances taken out of a
That's
vast
a
array.
different point. My point is, we're not being asked to look at a whole mass of documents.
You've heard my submissions, my lord.
Okay.
Now, turning to the main event, if I can put it like that, my lords, if I could begin by providing a roadmap as to how I'm going to address my submissions. And in the course of providing that route map or roadmap, I'm going to identify those points which, subject to the approval of my lords, that my learned junior will address this court on.
You
in
can
the
take
court.
that approval.
Thank you very much. So, in a nutshell, I'll address the court on the issues in the same order as the learned judge did below, rather than strictly in the order set out in the grounds. Now, there's a reason for that. That's to allow my learned junior's submissions to dovetail more conveniently with mine. I will also address the additional grounds and the cross appeal in the course of my submissions. I should say at this stage that unless my lords wish otherwise, I don't intend to take up time with the correct approach on appeal, which I believe is uncontroversial. The key points are set out in my skeleton of argument at paragraphs 16 to 18. And having heard the interventions from my Lord Justice Zacaroli in the course of this morning, I'm well aware that he in particular has the points firmly in mind. So returning to the route map, first I'll address the court on the issue of the principles of law applicable to revocation under section 46 of the Trademarks Act 1994. And in particular, I'll make submissions on section 46(5) of the Act and the correct legal approach to determining a fair specification. And these principles, of course, are relevant to grounds 2, 3 and 4 of the appeal before my lords. And that's in respect of the first Easy Life mark, the second EasyJet mark and the Easy.com mark. Now, the application of those legal principles to the fair specification as they relate to the first Easy Life mark will be dealt with by my learned junior, who is also dealing with ground 1 of the appeal, which is the variance issue, which again is relevant to the first Easy Life mark. And those are the issues which my learned junior dealt with before the judge below. And there are also issues that my lords will have had the benefit of hearing submissions from Mr Edinburgh and Mr Aikens in the appeal that was heard yesterday.
Yeah.
Second, I will address my lords on the application of the principles in respect to the second EasyJet mark and the Easy.com mark. And then I will then hand over to my learned junior, Mr Aikens, to deal with the revocation issues that I've already alluded to, and that's the variant use and the fair specification of the first Easy Life mark. My learned junior will then hand back to me, and I will deal with all the issues relating to infringement. That's grounds 5 to 8, and I'll make those submissions largely on the assumption that my learned friend is correct in his grounds of appeal on a revocation. Although I can say to my lords now that in a nutshell, it is our position that even if the appellant is correct, the results and the questions of infringement do not change. Finally, my learned junior will address the court, if necessary, on the contingent validity attack that my learned friend just referred to a short while ago. So if I could turn now to the revocation. Now, before turning to the specifics of the correct approach to partial revocation, it is in my respectful submission necessary, and particularly in light of what my learned friend has submitted this morning, to keep firmly in mind why the court is considering the issue at all. in the present appeal, this is in the context of an application for revocation for non-use. And that's unlike the position in Skykick, which was concerned with the partial invalidity on the grounds of bad faith. So if I could,
Apply the same principles.
my lord, if I could perhaps, it is, but the policy reasons are different. And as I believe my lord has referred to in previous
is that
cases.
right? Is that right? Because yes, of course, you're right to say that in the one case you're dealing with revocation for non-use, and in the other case you're dealing with invalidity on the ground of bad faith. But both situations are concerned with a situation where the registration is too wide. It's either too wide from the outset or it's too wide having regard to non-use. And the question is to what extent it needs to be slimmed down. And the same principles are applicable.
The same principles are applicable, but one must be very careful because, of course, as my learned friend referred to this morning, the onus of proof in cases of non-use is firmly on the proprietor, and it is up to them to provide the court with evidence to support the registration if it is to stay on the register. And that is somewhat different, or potentially different, from the situation such as in Skykick, where the basis of the attack is bad faith. Now, my lord is right, with respect, my lord is entirely right that more generally the principles and the way the court approaches, for example, the issue before it, it's doing so from a slightly different perspective and on the basis that the proprietor must provide the evidence. And that's the use it or lose it proposition that my learned friend referred to this morning. And it's for that reason that section 46(5) refers expressly to partial revocation. Now, it may be of assistance, my lords, to turn to the judgment in this case, which is behind tab 10, and turn to page 133 and look at paragraph 129. And this is because this is a convenient place to start. It sets out section 46 of the 94 Act, with which my lords I know have seen, which is the use within a period of 5 years. There's the reference to in subsection 2 to variant use, which is the issue that my learned junior will address my lords on. And then in paragraph 5, we get where grounds for revocation exist in respect of only some of the goods or services for which the trademark is registered, revocation shall relate to those goods or services only. So that's the cutting down provision. Then of note, which may not matter too much, the relevant 5-year period that the court was looking at in this case is set out 4th of February 2017 to 3rd of February 2022. And there's no dispute that the case was going to be resolved in that way. Now, the learned judge set out the essential principles to be applied to what he had to do by reference to my Lord Justice Arnold's judgment in EasyGroup and Nuclei. And I don't think and there's no suggestion by anyone that summary is wrong, but if I could just draw my Lord's attention to a couple of the key points. Point 3, the use must be consistent with the essential function of the trademark, which is to guarantee the origin of the goods or services to the consumer or end user by enabling him to distinguish the goods or services from others which have another origin. Turning to 4, use of the mark must relate to goods or services which are already marketed. And my lords will see internal use does not suffice. And then again, nor does the distribution of promotional items as a reward for the purchase of other goods and to encourage the sale of the latter by use. 5, the use must be worked by way of real commercial exploitation. It must be in accordance with the commercial raison d'etre of the mark, which is to create or preserve an outlet for the goods or services. And then 7, use of mark may not always be quantitatively significant. Even minimal use may qualify, but it depends on the sector concerned. Turning to what my Lord Justice Arnold then
That
said
may
in
be, that may be a convenient moment. So we'll come back again at 2 o'clock. Thank you very much.
Thank you.